This Tuesday afternoon, April 1st, and we are continuing to take testimony on S45, an act relating to protection from nuisance suits for agriculture activities. And we'll start with John Groveman. Thank you for being here, John. Please identify yourself for the record and proceed.
Good afternoon. Thank you for allowing me to testify on this bill. For the record, my name is John Groveman. I'm the Policy and Water Program Director for the Vermont Natural Resources Council. And I don't come to this committee a lot. I haven't been here this year, and I have been here in previous years. But the committee's changed a lot, so I just want to introduce myself a little bit, especially relevant to this bill, and then a little bit about VNRC. I don't know how many people know who VNRC is. So Vermont Natural Resources Council, or VNRC, we're Vermont's oldest and largest environmental group. We've been around for more than 60 years. It started really by farmers and foresters concerned about the changing landscape and development patterns in Vermont. And we've grown to have about 15 staff people and 4 programs. We have a water program that I lead. There's a forest protection program, sustainable communities programs that deals with land use and things that we call smart growth that you hear about when Act 250 bills are on the floor, and transportation issues, and a climate and energy program. I am the policy director, as well as focusing on water, but I'm also an attorney. And relevant to the testimony I'm going to give on this bill, I've worked for Agency of Natural Resources twice as an attorney, once as a young attorney. I was once young. And then once as an older attorney, I was general counsel during the Shumlin administration. So I've seen these issues about farm practices and pollution and liability from that governmental perspective. I also, for 10 years, have taught a environmental law class at Norwich University, which includes a section on common law, not just our federal environmental laws. And I do a whole unit on the common laws of trespass and nuisance and common law remedies. So I get to talk about those every year with undergrads, which is exciting, and it's exciting for them. I know that in my heart that it is. So anyway, I bring those perspectives to this issue. So you heard really good testimony last week from my colleague, Scott Sanderson at CLF. So I want to be, Scott and I work on these issues together. I'm not going to repeat what Scott said. Hadn't worked with Professor Echevarria on these issues before. I've known him for a long time. And I want to just endorse their testimony. I support Scott Sanderson's testimony and the comments and testimony of Professor Echevarria with regard to the concerns about trespass and takings. And I'm going to talk about really 3 points and try to emphasize different aspects of them than Scott and Professor Echevarria did, so not to be repetitive. But I'm going to talk about why I agree that trespass should be stricken from the bill and is the expansion of the right to farm law that is problematic. I want to talk about working on the standard. You heard a lot about the need for clarity in the bill, in how the law works today. And we're not opposed to reworking the law if people feel that there's a lack of clarity. But I want to talk about why the standards in the bill now for determining whether a farm would have the privilege of the right to farm enhanced protections against liability, I think, are not clear and don't work, and offer some suggestions. And then I want to just talk about what's the best way to try to get to a bill that creates the clarity that we want and does the things that we want in terms of farm liability. So trespass. So you heard, like I said, I endorse what CLF's testimony and Professor Echevarria's testimony on trespass. I just want to stress, and Scott did say this, in his testimony, but adding trespass to our right to farm law really puts us out of sync with all of our neighboring states, Massachusetts, New Hampshire, New York, Maine, do not have trespass in their right to farm laws. And as far as we could find, only 2 states do, and you've heard about those states, I think Oregon and Kentucky. It would put us way out of sync with the rest of the country. And the reason I think that is that, and you heard a little bit about this last week, but I just want to emphasize this, is that these right to farm laws are really rooted in this idea of nuisance, of the idea of if people are really coming to this nuisance, if people move to where a farm is and a farm has been operating for a long time and there has not been a significant change in the farm operation, that just because someone new comes to this area and smells and hears noises and experiences activities on that neighboring property as a farm that they're not used to, that should not constitute a nuisance, and the farm should have some protections against those situations. Adding trespass really is a game changer because even though, as you know, as we discussed last week, there is some overlap in terms of nuisance and trespass. Trespass really brings in the physical entering of someone else's property. It really brings in issues of discharges, which brings kind of being our seat at the table. So as I said, we're state's oldest and largest environmental advocacy group. Why are we following this liability bill? It's because adding trespass really goes beyond, I think, the traditional reason that we have right to farm laws, and that they're really rooted in these nuisance issues. And I want to give an example that doesn't involve tile drains. So I don't think this bill is or should be about tile drains. I don't think this bill is or should be about one case. I'm not going to even talk about the case that you heard a lot about last week, because it's really about a fair statute that, as Scott, I think, articulated really well, that has a balance, right? Balance is, farms that are operating and have been operating for a long time, people coming to those areas and experiencing, just like I said, the classic nuisance, and not having those sort of conflicts end up in court, with allowing legitimate claims that people have because an activity on a neighboring property has caused them harm. Trespass brings in issues that we think should go to court. And when they go to court, they're difficult issues to deal with. The burden is still going to be on the neighbor to prove that with regard to trespass, that there was a physical entering of the property, that there was harm. You have to prove harm. The last time I was really in this committee was to talk about bills around toxic pollution and liability. And we had a lot of discussion when we talked about those issues about how hard it is for a plaintiff to win these suits. It really is difficult. You really, to prove harm is not an easy thing to prove. In the toxic context, it's against large corporations with tremendous resources. But in any instance, the burden is on that neighbor, but it should not be, there shouldn't be enhanced protection and enhanced obstacles put in the way. And let me give you an example of a discharge that has happened, certainly within the country, that could be brought into this bill if you include trespass. And that is, let's say there's runoff from a farm, and the farm uses pesticides, and there's pesticides in that runoff. And that runoff goes from the farm onto the neighboring property, goes into the soils, goes into the drinking water well of that person. That's a trespass. Person tests the well, finds pesticides in the well. Our position is, under the law in Vermont, if that person has been harmed by that discharge of pesticides onto the property, they should be able to access court. They have to prove that there's been the physical entering of the property by the water. They have to prove that that water had dangerous pesticides, and they have to prove that it caused them harm. But if it did, and their well is contaminated, they need to replace the well. They get sick because they drink water that's contaminated with pesticides. They shouldn't have an extra burden on them to basically prove that the way S45 is written, well, did the farmer comply with generally acceptable practices with regard to pesticides. That shouldn't be an extra hurdle that is put there. And that's different than the nuisance issues. It's just different than the classic nuisance, the odor and the noise and the other activities. So I urge you to remove trespass from the bill, as you heard last week. As I said, it's expansion that is inconsistent with most states in the country, with our neighboring states, and would result in an unfair situation like I just described, and let people, if they really are harmed in that way, access the courts and not have to deal with an additional hurdle. And I want to say that I really appreciate the attention that the committee is giving to these issues. In the Senate, we didn't get into we didn't get into this sort of depth on kind of the trespass issue. And I think it really is an important issue and deserves this attention that you're giving it. So that's my first point. Yeah.
Before we move on to trespass, I'll just ask you a question. So I'm going to give a hypothetical as far as if there is an existing farm with existing property owners, and that farm is, I'll use water as an example, and it doesn't have to be tile drainage, whatever, but has openly and notoriously, using some language from
adverse possession,
but has been trespassing essentially, or could be considered trespassing on that property with water. I'll just use that as the example. And then somebody buys the property. This farmer has been using whatever their practice is that's causing that deluge of water, but the property owners have been fine. You're fine with it, and it's been that way for years. Now you get a new property owner that comes in, and they want to sue for trespass. That scenario I could possibly see wanting to cover with something like this, because it's kind of similar, like coming to the nuisance. It's like coming to the trespass that has been accepted because it's open and notorious, and one could argue adversely possessed. Any comment on that kind of hypothetical? Or
I mean, I think the laws of adverse possession should apply there. If that really was the fact that the farmer in that case said, hey, basically we had an easement essentially, to a right to use that property. But I would argue that even if that's true, though, like if there was contamination added to the water, that'd
be changing. That'd be something new. I'm just saying whatever the water was.
But then you have to prove. Then you're into proving that. Like, why would we? I think that is. I would think that, if there's a drainage ditch, I don't think it should be treated as something, I think it should just be like I said, you should be able to enter the court and make your argument like that. If there is contamination, that you just don't, it's still hard. Like I said, it's not at all like you're just going to walk in and someone's going to give you a check, or say that you win in court. But I don't think that that's the situation where we should create another hurdle for a landowner even if there's a change that ends up contaminating the property. That's not the type of change. I think when I look at the nuisance laws, the type of changes are expansion of the farm, in terms of the area, different type of farming that's going on that significantly increases the amount of, noise or odors that could come from a property. But I just think that these issues of sort of contamination and physically entering the property are different. And I think if people want to argue adverse possession, then they can make that, defense in court that they had the right to be on that property. And then the issue turns, well, did you have the right to contaminate the property? Let that go to was there a physical entering and was harm caused? And then have that out, but not layer, another requirement on them before you could really even get to those issues.
Let me ask you one other question on the trespass as well, is that I'm trying to make sure I understand the way I'm reading this, that you could have a practice, and I'm looking at page 3, the generally accepted agricultural practice, and you could have a practice where something is consistent with proper and accepted customs and standards followed by similar operations of agricultural activities in the state, but it's something newly put in place. And now there is more water or more contamination flowing onto somebody else's property. I mean, is this the way I read this? Is that that trespass couldn't be brought if they were following the accepted practices. Is that right? I mean, am I reading this right?
Well, I think there would have to be an argument first, or that would be a defense. And that's a point I want to make that was made last week, is that this isn't preventing these suits from occurring, right? It would basically create like a threshold argument, right? Before you could get to to your claim that you really wanted to argue. You'd have to go through the way S-45 is constructed, what generally accepted practices follow that would bar you from really getting to the trespass elements, which are physically entering the property and the harm. And then it adds on, this gets to my concern about the clarity. I just don't understand how the negligence, then there's an S-45, you'd have to show negligence. So, it's basically that you're following the general accepted practices, or you're negligent. So then you'd have to have this negligent analysis that's done, right? And that if it was found by a court that the farmer was negligent, I guess then your claim could go forward. And I guess the way I read the bill is then you'd go back to having to prove trespass or nuisance, right? Which is very confusing to me. I don't see how that's helpful. You're going to end up having this whole decision, right? In order to figure out negligence, you'd have to have discovery. You probably have to have some sort of preliminary trial or hearing. You're going to have findings of facts. You have to have the decision of some sort. And that's all before you get to bring your trespass or nuisance claim, right? All of that is for the ability to go and then make your argument. And I think all we're saying is that, at least with regard to trespass, don't put people through that. Just like let them make their argument that the elements of trespass are met. And that's hard enough. And, that is a fair way to both parties could get to argue their case in terms of trespass. And then with regard to nuisance, we're agreeing that the existing law, the policy behind it, that if you come to the nuisance, if your issue is not a trespass issue, but it's more of like a practices, than odor and noise and other sort of impacts like that, if you want to layer a threshold issue, that we're not objecting to that. Although I think it's important to note that under the existing law and under S-45, even with nuisance, you still have to have some sort of preliminary decision, right? You're still going to have debate and discovery and analysis and a decision on whether or not generally accepted practices were followed with regard to the nuisance issues and whether there was negligence.
So is this essentially creating a negligent trespass
Seems so, right?
standard?
Yeah, exactly.
And to prove negligence or to try to argue against the negligence, as the farmer, wouldn't they argue that while they are following those, the reasonable practice, they are being
That'd be one of the defenses. Yeah, obviously, yeah.
kind of gets circular a little
Right.
bit, but
So I think it's confused. So I would think if you did take trespass out, we think that would be a big improvement to the bill. But I think we need to do some work on the standards. I totally understand that people feel that the current way the presumption works and what the farmer needs to do to establish that presumption is not clear. And that's not the way we want this to work. But I'm not sure. I just don't think the way this is constructed adds a lot of clarity. I think it'll, like you said, it creates like a negligence and trespass standard. And then we get into the issue of what's compliance with generally accepted practices, which I can only speak to with regard to water, because that's my expertise. And that's, so that's the next thing I was going to talk about. So
unless there's other questions on trespass.
So just one quick question about trespass. I understand we're talking about the trespass part in water, but what about other things as well, like farm animals?
I think that if you have animals coming onto your property, I guess you should be able, you have to show harm. You have to show
Well,
what
yeah,
the harm is,
They usually cross the fence for a reason.
Yeah, I mean, I think that I would just keep it. I just think I don't know how to parse that out. Again, you'd have to, in order to go to court, you'd have to have some significant harm. And I don't know, I'm not a farmer, so I don't know how much harm animals can do, like crossing over your property. Yeah, I don't know what the harm is though. And I would hope those things usually get worked out, but I'm a water expert, so I can't really speak to that part
So
of the
when you
issue.
speak of nuisance trespass, what your focus is water.
Yeah, certainly with regards, those are the examples that I know as trespass, but, you could maybe ask another witness about the farm animals, but I would think, you'd want to know what the harm is and, how often that occurs and, could you, you deal with that with the nuisance part of it or not? I really can't say.
Karen?
Thank you. So I'm just going to try to summarize from the trespass piece. I think I'm getting at that. There already is a means to tackle trespass. Like if you feel like trespass has happened, that you could take it to court and go through that. So not saying that it's needed in this because there's already a path. Is that correct?
Well, and that there shouldn't be that it's hard enough to prove, and within the water context, it could be serious enough that you shouldn't create another hurdle. Like the hurdle that exists is already hard. That's why we don't see a lot of these suits. And in any context, like in the toxic pollution context, you really have to have a significant release or discharge and then harm to get people to the point that they need to go to court to like try to deal with the damages that they've suffered, whether it's to their health or to their property. And I'm saying, don't add another hurdle. What this bill does is expand these existing protections, these existing provisions that make it harder to bring one of these suits. And I'm saying that wouldn't be fair. Like what we want is a balanced law. I get the nuisance part of it, like I said, but I think in the trespass context, it's already difficult enough for like an ordinary person who's been harmed to go to court to make that claim and to prove it. Don't add more onto that, basically.
And what I'm hearing your take is, but the nuisance could keep it because it could be that extra level of deterrence of folks putting out. I guess I'm just going to put it, and I realized I wasn't here for some of the testimony. Did we get data on this at all to know like how many nuisance claims are going out a year or how many trespass that?
I think essentially we heard that there's the one case that people were able to identify.
Okay. I just feel like this is helpful just hearing this in this context because I hear this piece of like, we want to deter folks from doing, but we also want to make it allowed. But if we don't even have the data to know how many of these claims are even happening, I'm guessing like
there've been very
why do you
few,
want
and
to change it?
we've had in the other years to be completely candid, and we're here, clearly there's a desire to bring some clarity to this statute. We hear that. So I'm here to say, we're willing to dig in and work on that. In years past, our position has been with the Conservation Law Foundation is there's only been a few cases over many decades. And that was an indication to us that the system was working. It was deterring suits. But so that's the data you'll hear, and I think that's in the record of the committee. But, if there's a statute that people feel isn't clear and it could be made more clear, and there's a concern about as demographics change in Vermont and we build more housing in Vermont, that there are going to be more potentially of these situations. We hear that and say, okay, well, what's fair? And we think what's fair is, like I said, the coming to the nuisance, like if you build a bunch of houses and you have more people move here and they're smelling things they're not used to smelling and they're seeing tractors crossing the road and, leaving things like in people's driveways and just generally engaged in those sort of activities that give people consternation. Those are nuisance sort of issues, and that makes we understand why you'd want to have an extra hurdle that you're saying before you would get to court. You would rather have the neighbors kind of work things out. You'd always want the neighbors to work things out. But bringing in trespass brings in, a whole host of other issues where you're adding that hurdle, especially in the water context. It's really concerning to us to do that. And it's still really difficult to bring those suits. Still really difficult. That's why I'm saying our neighboring states don't include trespass. Most states in the country don't include trespass because I think that the nature of these laws really were to deal with. If we're adding these hurdles, I think Attorney Bent really put it well. Like we're basically, creating, a privilege in, a class of people that are protecting them from liability. And we should be very judicious about, when we do that and how we do that. And I think that you're seeing, VNRC and CLF come out and saying we're concerned about that expansion of these things. Professor Echeverria are raising issues that I had, quite frankly, had never even contemplated, that it would result in a taking of property. So yeah, that's the core argument. That's not for that class of disputes involving trespass. Let's not add that into the law. So the standard issue, and so this is, I agree. I've looked at all the right to farm laws around the country, and many of them do include some sort of standard, like let's focus on nuisance. For nuisance, if you're complying with generally accepted practices, that you qualify for the protections of the right to farm law. But again, and maybe this is more of an issue if you leave trespass in. With regard to water, I want to highlight that there has been this ongoing dispute in the state of Vermont about what are the generally accepted practices that are adopted by the state of Vermont, which have come up in this committee. They're called the required agricultural practices, and they include practices that address water pollution on farms. There's been this ongoing debate about what is needed to comply with those practices. VNRC and CLF, we submitted a record request, and we collected records for several years, communications between the Agency of Agriculture and the Agency of Natural Resources. And those records showed us, and we did that because we were getting complaints. We get complaints from our members saying, I see discharges from farms going mostly to public waterways, causing environmental harm, and nothing's being done about it. There's not an enforcement action, a permit's not required. So, we've been working for years on Lake Champlain pollution. It's well established that, agricultural pollution is a large percent of the pollution problems in Lake Champlain. So we submit a record request to see what's going on in the agencies. And what we found was numerous disagreements between the Agency of Natural Resources and the Agency of Agriculture about whether a discharge on a farm was complying with the agricultural practices around water pollution, complying with state water pollution control laws and federal water pollution control laws, with the Agency of Natural Resources often saying, we think this is a violation, we think a permit is required, and the Agency of Agriculture saying, we don't agree. And they start to, argue with each other, and the enforcement action is not taken, permits are not required.
Okay.
What you're saying is making me think, but trying to find out if folks were following these required agricultural practices. That's what we're getting, right?
Right, exactly.
And I guess for some reason, my mind went to, is there a site that you can go to? Like we do this for so many professions to see if folks are in line with regulations or not. I'm guessing that's not the case for farmers or whatever, that there's not a place you can go to and see, is everybody in
No, I mean, I think it's sort of in the
compliance.
negative. It's like if you haven't had a violation issued to you, or haven't been required to get like a special, a water permit from A&R. A&R has never issued a water permit to a farm in the state, and they're supposed to under the Clean Water Act if there is a class of discharges, which in the records we saw, A&R believed at times there were, that would have required this water permit from A&R. Agency of Agriculture does issue their own permits that include water, but under the way the federal and state law works together, at some point, A&R is supposed to take control of the situation if a discharge is of a certain type and, there's a certain situation, and that's never happened. And so just to finish this story.
Sorry, may I just to for the compliance piece of it. So there's nowhere that the average person can look up to see if farm or agriculture is in compliance.
Yeah, as I said, I think it's in the negative. Like you could see if there was a violation, but you can't, I don't think there's a website per se, but I'm sure you could try to get that information, but it's not clean and easy as I think you're suggesting. But so we ended up petitioning the EPA because under the Clean Water Act, states can be delegated under the Clean Water Act the authority to issue and regulate water pollution. And Vermont has that delegation, and the Agency of Natural Resources is that delegated entity. And under the Clean Water Act, if there's evidence that the Clean Water Act is not being properly implemented, you can petition and ask that the delegation be removed unless there's corrective action to address a problem administering the Clean Water Act. And so CLF and VNRC and Lake Champlain Committee filed one of these petitions with EPA and said, here's our records, here's our evidence. There are farm pollution discharges that are in violation of state practices that are also in violation of federal law. A&R should be requiring permits. There should be enforcement. It's not happening. We're still in the midst of that petition process. EPA did issue a preliminary finding that they agreed with us that the Clean Water Act was being violated and practices were not being followed in Vermont, and discharges did exist that appeared to violate the Clean Water Act, and that corrective action needed to be taken to restructure our laws in Vermont, our practices with regard to water pollution, to basically come into compliance with the Clean Water Act. And we're in this process right now with the Agency of Natural Resources and EPA to identify what those changes are. And there's a bill in the Senate that I testified this morning on, working on how to take steps towards reforming that system. So why am I bringing this all up? Yeah. So I'm bringing it all up because it's been hard to explain, and maybe I'm crazy, and you can tell me if I am. But if we're going to write a right to farm law that's going to lean on compliance with practices, at least in the water realm, the story I just told is evidence that in the water context, it's not clear, like, what does that mean to be complying with the practices? We're trying to rewrite the water law in Vermont to make it clear. And I think we'll get there, but we're not there right now. And so that makes me nervous to write a right to farm law, at least in the water context, that basically provides protection if you're complying with generally accepted practices, fully acknowledging that many states use that terminology. But states also use some states use different terminology. Sometimes states will say you get the right to farm protection, unless you can prove that a farm practice has adverse or substantial adverse health consequences or damages to property. We have that sort of standard now in the presumption that we use. New Hampshire uses that standard. They don't rely on generally accepted practices. Other states do in our region. They do that. But this gets to my point of, like, I'd like to work on what the standard is. Because, while we're having a debate, at least in the water context, about what constitutes compliance with practices, I just think it's unwise to use that as the standard to create this privilege and extra hurdle about bringing these cases around farms. And there are other examples. And Scott and I did some research this weekend. We have examples in other states that have language that does not lean on the generally accepted practices, which we'd be happy to forward to the committee. But we do think it's really important to discuss what standards that we create. And I think that our experience with at least the water standard is instructive in that it's just not so clear. Now, in the Senate, Attorney Collier, who's the general counsel for the Agency of Agriculture, testified, and I'm sure he will testify today, that he thinks everything I just told you is irrelevant, that it's really not the government's. And this is important. This came up last week. People aren't going to go to the government. The government is not going to intervene in these right to farm lawsuits and be witnesses and say whether practices are complied with or not. What I've heard from Attorney Collier is that the burden will be on the plaintiff to prove that there is not compliance with generally accepted practices. And at least in the water context, it gives me concern that if you have the two agencies that are expert in this, the environmental agency and the agriculture agency, and they can't agree on what complying with the practices are. Now you're going to ask a private citizen, yes, they'll go through discovery. Yes, they'll gather evidence. Yes, there are some issues, and you heard this last week about who's in the best position to know what's actually happening on farms. But, I could see, the discovery process, I think, is a way to overcome that hurdle. But I do think, it gives us concern about using that as the standard for the right to farm law. And we'd like to be able to suggest some alternatives to determining, when the right to farm protection would apply.
So is that a bigger issue with the trespass than the nuisance?
I think so. I think eliminating the trespass does mitigate the concern about that because it does allow an avenue to address the water issues that would be outside of the scope of the right to farm protection. So I do agree with that. I can't speak to the other practices around odor, practices around noise. I can't speak to those. Maybe they're not controversial. Maybe they're easy to ascertain. But if you're including water in this, that's what I know, and that's what I've seen. And we're still in the midst of this, you know. And I'll tell you, I was in the Senate Natural Resources and Energy Committee this morning. There is a lot of confusion about what is necessary to comply with agricultural practices with regard to water, to trigger federal, you know, Clean Water Act permitting, and we're still working through it. And it is really complicated and difficult issue. But that's why it makes me nervous to like in a statute that is going to be is going to affect civil liability, especially with trespass and with regard to water. That gives us a lot of concern. And the other reason I think is relevant is if you have a regulatory system, and Scott mentioned this last week, that's not working. And then you're like putting it on private citizens to lean on that system as the standard, you know, for when they could bring a private action to be made whole and recover. That just seems unwise.
Angela.
So are you referring just to the required agricultural practices or the required agricultural practices and that 2C where it's just called consistent with proper and accepted customs and standards?
I'm really talking more about the required agricultural practices.
Okay.
Yeah.
Thanks.
Yeah. Ian.
If we were to copy the language in the existing statute, but like shift the burden to the plaintiff so that it was basically the plaintiff's responsibility to find out whether the farm is acting in conformity with federal, state, and local laws and regulations. So it like spells it out like that. Would that alleviate some of your concern? Because if the plaintiff were able to identify any one of those that the farm wasn't in compliance with, they would satisfy the burden.
I like to think about that a little bit. I mean, I think I would prefer to rework. Like, I think if we were like, I think it makes sense to, you know, and I don't know if Scott even agrees with me. I'm interested to see what he says when he testifies on Thursday, but I think it makes sense to eliminate the presumption approach to this. And yeah. But to me, it's more what the standard is, and make it clear that the burden should be. This is the issue we focused mostly on in the Senate, which was odd to me. Was like the burden. They were really focused on that it was unfair that the farmer had the burden to show that it was in compliance with practices to get the presumption in the first place. So that's what makes me think maybe we should just get rid of that. Although like our point there was that the farmer is in the best position to know, and that once the presumption applies, then the burden shifts, you know, to the plaintiff. The plaintiff not only has the burden to prove the nuisance or trespass and that got added, but would also have the burden to show that the presumption should be rebutted, you know. So, but it does obviously created a lot of confusion in the Senate. And then there was the discussion, you heard a little bit about it, about what are the elements the farmer must prove to get that presumption.
Yeah.
So I think if you're going to leave the presumption, we should look at those, you know, and just clean that up a little bit. And I think that would be totally, you know, a fair thing to do.
All right. Other questions? Or did you have more that you were?
I think that's really it. I just, you know, if you're interested in working on language, like we're ready to dig in. Like Scott and I have already, like I said, we've looked at, you know, some other standards that could be applied. You know, on other years we have talked about, because this bill's come up before. I'm very old now. I've been working on things for a long time, but at least in the last 5 years, it's come up several times. We suggested along the way, like rather than like me and Attorney Collier, uh, just arguing and Attorney Sanderson, like, could we like, we suggested like some sort of stakeholder process or something, but if the committee wants to move on this issue, we're prepared to dig in and offer language and go back and forth, but it is confusing and it might benefit from that sort of, process to like, to get people together and what's the best way to write this language with some guidance from the legislature on what to focus on and how to do it, because there could easily be unintended consequences with these things that, that are literally unintended. I don't think there's any bad faith on anybody's part, but it's just, you pull one thread and the whole thing starts to unravel. That's the last thing I guess I would say.
Any other questions? Yeah, Barbara.
So I'm wondering if things change at the national level, is there anything that we would need to do in Vermont, given what the EPA's role has been? And that we should be considering?
Writ large, definitely. I'm not sure that like this bill is like, I do think is relevant. So writ large, obviously everyone is really concerned, like we at the NRC just, the last 2 weeks, EPA has proposed a rollback of, I think, over 30 regulations and programs, related to climate, related to toxic pollution, related to water. I do think we're analyzing, and I would hope the Agency of Natural Resources is analyzing like what we need to do as a state to be a backstop if that happens, But I think as relevant to this bill,
Yeah.
I think, and this is kind of the point I was trying to make before, is that we don't want to, like, especially when it comes to like not nuisance issues, but the sort of contamination issues that we don't want to, private citizens unfortunately are going to bear more of a burden to try to protect themselves. And it does, end up protecting our public waters because, or groundwater, like let's just stay with the pesticide, groundwater in Vermont, the legislature did this, 16 years ago. Groundwater is a public trust resource. No one owns the groundwater. It belongs to all of us and needs to be managed and protected for the benefit of all Vermonters. So if there's groundwater, give my pesticide example, that's an issue that Vermont government, the legislature, the agencies, is responsible for. But private citizens are often on the front line. If our federal laws are weakened, we don't want to make it too hard for citizens to access to deal with that sort of pollution. So I think that's how it's relevant to this bill. And that's the type of unintended consequence, which I don't think anybody intends that to be the case, but we see that, especially in the water context, which is my lens.
Ian.
One other quick question. Just thinking about getting rid of the presumption structure altogether. Are there any states that have a right to farm law that doesn't use the presumption?
Oh yeah,
structure?
many. Yeah.
Any in the Northeast?
Yeah. I think and Councilor Grady could probably speak this more, but I don't think any of them have the presumption structure. I think we're the only one. Like the ones New Hampshire, I said, has the sort of the standard I mentioned.
Yeah.
A couple of them have a standard which I don't like, which is, and it puts a lot of pressure on state government, says, you get the protection for nuisance if you're complying with practices as determined by the Agency of Agriculture or the Secretary of Agriculture. Like, I just think that puts it, I don't think with given the resources we have, I don't see that. Like I said, I don't see the Secretary of Agriculture or his or her designee like showing up in court, doing that. So the two of them do that, but yeah, no, I don't know. We're unique, I think, in the presumption.
Okay, I misunderstood.
Yeah, I think so.
Okay. Thank you.
Yeah. So thanks for listening.
Yeah, thank you very much for your testimony. I appreciate that. So we're going to go to Justin Rich next. If you're still there with us, Justin, if you can unmute yourself and identify yourself for the record and proceed with your testimony. Thanks for being available.
All right, thank you for having me. My name is Justin Rich. I farm produce in Huntington, Vermont, and I'm the current president of the Vermont Vegetable and Berry Growers Association, although I'm more or less speaking on my own right now. Didn't have a ton of time to prepare for this. I have a question for, it looks like Mr. Groveman left the room, but I'm not sure of what the difference is between just a presumption of innocence in general versus this trespass presumption that's being put into the bill. the question for me is even the best practitioners in a field like agriculture, every once in a while, have something bad happen. For instance, in our valley this past summer, we had water 3 feet higher than any living human had ever seen. I personally lost hundreds of thousands of dollars worth of crops and fields, and I was doing everything by the book correctly. So could I have then been sued by a neighbor downstream because something definitely left my farm and crossed onto their property? And I'm just unclear of why the pushback from some folks about giving farmers the benefit of the doubt, given the fact that most of us really are trying our damnedest to not dump what shouldn't be in the rivers in the rivers. Um, and there's a lot of science that says, what farmers in Vermont are doing has been quite amazing at reducing our phosphorus load specifically into Lake Champlain. And sometimes I feel like that's not pointed out in a particular way by some groups. Um, so in an era of climate change like we are in, I feel like removing some benefits of the doubt from the farmers that still remain in our vastly diminished ranks in the last 20 years. It just makes us feel like sometimes we're in the crosshairs. So I think I just want to have like, does anybody in this room have any questions for a farmer? Now, I'm a produce farmer, so we don't have manure per se, but we do spread manure-based amendments. And we are just one of the people who are trying to feed humanity in a way that does as little harm as possible to the environment in which we all live and try to enjoy. Um,
So,
yeah,
yeah, let me see if there
yeah.
are questions, unless you had more.
No, I like I said, I'm not a lawyer. I don't have a very bullet pointed spiel to discuss, but I like to think I represent farmers who, I always say in a meeting like this, I came into farming as an environmentalist. That's why I got into farming. I always felt the most direct way to have a positive impact on the world around me, and I could not think of doing anything else with my life. And there are a lot of farmers who are just like me. And I do have a unique perspective in that I'm a first generation farmer, 2 generations removed from dairy farming. Um, and what I specifically like about this new right to farm bill is that it's addressing the fact that previously you were only protected from nuisance suits if your farming activity predated a potentially aggrieved neighbor moving into the neighborhood. And as somebody who just started my business 15 years ago, there are a lot of people who've been here longer than I am. So are my irrigation pumps seen as nuisances? And in the current language, I like the fact that it covers the scores of, younger and first generation farmers who have had to try to nestle their farms into perhaps slightly more urban, suburban neighborhoods in Vermont. So I'd like to address whoever, the authors of this bill and thank them for that, because I feel like that's a specific provision that helps cover the younger farmers who are not multi-generational in our state. Um, so
So,
yeah, go ahead.
yeah, Angela, then Karen.
Uh, Thanks, Justin. I'm wondering if, um, for you and for, your farming colleagues, the farming community, do you have a good understanding of what, is meant by the, how did I lose it? Proper and accepted customs and standards, followed by similar operators of agricultural activities?
Yeah. I think in the farming community, that's generally pretty well understood. Of course, there are bad actors. There are people who are doing what they're not supposed to be doing. But I think the threat of that is lower than the threat to the farm community from people who have very, very little agricultural context. I have had the authorities called on me because I was, quote, dumping manure directly into the river, when what I was doing was buying compost and putting it in a pile 400 feet from the river. I have had yeah, so that's just an example of sometimes a passerby, it's really easy to call the police or call the town administrator and complain about what a farmer is doing, when the reality is the only crime right there is that the person doesn't really know how farming works. And um, we can't expect everyone to be an expert in our fields. Um, but
Okay.
the required agricultural practices honestly are very common sense. I don't hear too many people complaining about them. It's something a lot of us would be doing anyway. Riparian buffers are just, we're an organic producer, so we have to have buffers anyway, but I would do it no matter what. So I've always considered like some of these RAPs the easiest thing I have to like check a box on, because yes, I default to them, as do most farmers I know. I'm sorry, is that enough for your question? As you can
Yeah,
tell,
yeah, I
I
think,
can ramble all day. I try not to, but
no, that's helpful because
talent.
that's a question of mine has, since we heard the bill introduced, has been, is there, since we're not pointing to a specific agency or a specific source for these generally accepted practices, I just wondered if in the field there is a sense of what those practices are and where you would look to make sure you were complying with them.
Yeah, a lot of the nitty-gritty of the wraps, as they're referred to, really covers more livestock farms because they have to deal with liquid manure. It's, and that is a much, your average dairy farm covers much more ground than your average vegetable farm. I always say like vegetable farms are extremely labor intensive and dairying is relatively land intensive. So you can, we can generate 10 times the revenue per acre as a dairy farm. So we have a little easier in some of this, waste
Right.
management places, which is what the
Right.
wraps mostly are governing.
Right, and so we have in the bill, we have the wraps, and then we also have this broader category, practices conducted in a manner consistent with proper and accepted customs and standards. So the wrap is that's a separate line, required agricultural practices, and then this like more general standard, I guess.
Yeah, I think generally the generally accepted would then get kicked up to, well, that's in the required agricultural practices. You'd have to ask perhaps somebody from the Agency of Agriculture if
Okay,
if there is a difference between those two terms or if they're just kind of covering their bases.
gotcha.
But
Okay.
and as a grower, the wraps are outlined and I can look them up.
Great, thank you.
But and my concern here is like, like I said, it did not happen, but this could have happened. I could have had a load of composted poultry manure delivered to my farm last summer in July, which is a very dry, one of our drier months. And I could have field stacked that in a place that has never seen water in the lifetime of a 90-year-old. And that could have all been washed down river last year. And I am a little concerned with some of the trespass language not kind of allowing for acts of God that overrun what would be considered extremely good agricultural practices, because that's the world in which we've been farming for specifically the last 20 years. Luckily, my career doesn't go back much further than that, so I don't remember the times when it didn't flood all that well. But I always point out to people that imagine trying to do your job no matter how much it does rain or doesn't rain and your job is outside. I mean, that's what farming is. It's the challenge is what makes it so satisfying, but sometimes the threat of um, honestly, the threat of accidentally doing something wrong and being held liable is kind of terrifying at times. When all we're trying to do is feed ourselves and our communities. And Vermont is still like we produce enough calories to feed all of Vermont in Vermont and then a little bit extra. And I don't know, I think that's something to be proud of for, a state in the densest part of the country.
So Karen.
Yes, Justin, thanks for being here and sharing with us. My question is about uh, the claims that have happened, because I think protecting farmers is definitely important, is what we can all agree on. I think it is the how is the piece. And so I'm curious with some of these examples that you've given of how bad things could have happened, or maybe they did, but you were following the practices. How many claims are you seeing of nuisance or trespass, or that you're hearing in Vermont? Because I think what we're trying to do is balance making sure farmers are protected, but also making sure that folks have access to filing nuisance claims when it is appropriate. And so I'm just trying to understand how many of these claims are out there already.
I think that's above my pay grade to answer in terms of how many claims there are. Like I said, I can respond to. I have leased land from our town administrator, and she would be the one who would get called usually when somebody had a complaint. And it was, once a year somebody was calling and complaining about something which made us all scratch our heads. Again, I never had to hire an attorney. I never had to waste more than an hour on any of these things. Um, but we are
Thank
a
you.
small farm. We
Yeah.
don't have the footprint. And also as we grow about 25 acres of organic vegetables, and we have we're pretty accessible in the community. So I think a lot of these things are just solved by being a good neighbor. Like our dairy farm neighbor, I know they have not spread manure on certain days because they knew somebody was having a wedding. Like being neighborly really solves a lot of these problems, and it goes both ways, like not complaining irrationally and then not being a jerk as the farmer. I know I get a couple funny text messages on the day when we spread our poultry litter compost in the spring, and I just kind of have to roll with it because it's not my favorite thing to smell either, but it goes away. Um,
You're seeing local kind of neighborly solutions, not, and
Yeah.
things aren't rising up to the court level.
yeah, but I watched the trial, was it 2 or 3 years ago, with like a pit of fear in my stomach that somebody, if somebody with deep enough pockets wants to hurt you, they really can. Because I'm not a poor person, but I'm not able to just hire attorneys left and right. So um, I appreciate this is all just moving forward as it is, and I think Harold Howergan's on this call. I think as a larger dairy operator, he could speak to some of the specific concerns that the dairy community has. I think my position here is just to say, like, it's not just the dairy farmers, and it's just not the boogeyman of manure. It's a lot of times just the things that farmers don't even think of as being nuisances can be perceived as nuisances by newer neighbors or even older neighbors who were used to having an abandoned meadow next to their house, and then all of a sudden they have some 26-year-olds growing sunflowers and potatoes in that field, and you know causing a newer problem. But I just think it's a statement that agriculture is valuable, especially in a rural state. And I don't think anybody in this room is going to disagree with that. I'm sorry, did I even answer your question at all?
You did, thank you.
Other questions?
Yeah,
Yeah, go ahead, Tom.
I couldn't agree with you more that somebody with deep pockets, that's a neighbor downstream, could create a problem, and just bring complaint after complaint after complaint and drag things out until, till breaking, or bankrupting somebody like you. But so I'm going to assume you, with issues like this, that you've talked to colleagues through the years, and I'm just curious on what those conversations were like with your colleagues over an issue like this.
The joke in the vegetable and berry world is we get to hide behind the dairy farmers. They're the ones out in the front taking most of the bullets, and we kind of but a couple of years ago, there was a bill basically seeing the vegetable farmers as an enemy because we were irrigating too much. Um, so you can stand behind other people only for so long until all of a sudden somebody puts their sights on you.
Right.
But it's
Yeah, I'm sorry, go ahead.
but like I say, in the vegetable and berry community, we generally have a pass because A, we don't spread manure for the most part. B, a lot of us are organic, and that gives a lot of coverage. Like I spray our crops with organic amendments, which they're not super powerful. They do help. Um, but I get the stink eye from some people sometimes driving a sprayer down our road. I'm like, I thought you were organic. I'm like, we are. I'm spraying kelp. You know.
But what goes through my mind, can that be considered a contaminant on somebody else's property?
Yeah, I think some of the stuff with pesticides is definitely covered by federal law. I think that's, what we always say in farming is like when you spray anything, whether it's organic or conventional, super toxic or basically foo-foo juice, like the label's the law. And as soon as you do something that's not on the label, which includes drifting onto a neighbor's property, you're in violation. So I think that's more or less covered, but I'd have to leave that to somebody who's maybe had to go down that path further than I have, which I have luckily never had to deal with a EPA
Right.
complaint on sprays. Like I said,
And
we're
one of the-
spraying kelp and fish guts. It can smell bad, but it's not toxic at all.
And just one of the concerns, not just for you, but all farms with the weather events we have, and the water 3 feet higher than anybody's ever seen it. I mean, that's anybody that's below a farm. I mean,
Yeah.
and I don't know, I think we need to, I think we need to cut the farmers some slack on this bill. I really do. And not take the trespass out. I just think it's gonna be detrimental to, not just the dairy farms, but I mean, the dairy farms feed us too, but if we regulate too much, it's gonna stop people like you from getting into business. And I'm gonna assume at some point, with the regulations that we have, it's probably pushed some people out. That didn't want to, upgrade their farms or whatever. Not that it wasn't necessary, but and earlier we heard something about not making it that with the trespass, it's an extra hurdle to a lawsuit. I don't have a problem with that because if something is being done wrong, an extra hurdle may be necessary, I guess, to do the right thing. But
Yeah, I don't find the need for a plaintiff to prove, to do discovery to prove negligent trespass to be all that bad, in my opinion. But again, I could see if I was the recipient of something really nasty from upstream, like, I don't know, maybe I have a different view. So I can see where people are coming from. But
Sure.
I obviously, I'm not going to pretend I'm not biased in this situation, but I do think farming is hard enough.
Yeah,
and,
yeah.
and risky enough to feel sometimes, especially after a year like we had last year, that I just don't know if extra burden is something a lot of the farmers are looking to carry. And to what you said about, farmers adapting to new rules, like one thing the state of Vermont has done really well over the years is if a new rule comes in that restricts something a farmer can do, there's usually funding to help farmers implement these. And those types of schemes are extremely important in forging the good outcomes that we need. Things like the state helping to pay for manure injectors and upgrades of manure lagoons, things like that. Those are very valuable in our state to achieve the environmental outcomes that we're looking for while not driving our dairy industry and other farming sectors out of business.
Right,
So I want to
right.
say thank you to everybody in the State House who keeps these programs going, because I know if all of a sudden somebody said, "Oh, to keep doing what you're doing, you need to put in $100,000 A, B, or C," I said, "Oh no, we're doing
Yeah,
okay, but not that okay."
at some point, it's over regulation, I guess. But where's that line?
Totally.
You don't know where the line is till you cross it, but
Yeah.
and
Well,
not
that's why you guys have
necessarily.
jobs.
What's that?
That's why you guys have jobs to find out where these
Yeah,
lines are.
right. Not that it's necessarily for you, but I was kind of questioning question I had last week. I didn't say it out loud. As far as this bill being in this committee, I'm kind of baffled by it because I think it should be in natural resources. I mean, buzzwords that I've heard: EPA, Clean Water Act, ANR, contaminated water, water discharge permits, right to farm, rewrite water laws. I mean, that's nothing we've ever dealt with, and that's things that the natural resources or ag deals with all the times. So I'm just really baffled why we even have this.
This is definitely my first time in the Judiciary Committee. That's for
I'm
sure.
sure it is.
It's good to meet you
I've been
all.
here 15 years and 11 years in this committee, and it's the first time I've ever seen anything like this in judiciary. So anyway, I'm done for now.
You guys are having too much fun. You're going to demand more.
I think supposedly our expertise is in nuisance, trespass, and taking law, but I think that we do have to have our friends in ag weigh in on this, definitely. There's no doubt. So, all right. So, did you have anything else, Justin, or are you good?
No, I've been enjoying listening to the legal definitions between these things because, again, not a lawyer. Watched some on TV, but no. Well, thank you.
TV lawyers are much more exciting than what you'll find in here, though. So,
That's what my sister says.
all right. Thanks a lot, Justin. We'll go
Thank
to
you,
Harold.
everybody.
Yeah, thank you.
Thank you.
We'll go to Harold next. If you could unmute yourself and join us, Harold, and identify yourself for the record.
Good afternoon. Can you hear me?
Yes, we can. Thank you.
Yeah.
Thank you for making yourself available.
Yeah, Harold Horgan, dairy farmer from Fairfield here. Good afternoon to everyone. I would prefer to be in person, but we're in the thick of our maple season up here, and it seemed more efficient use of time to utilize our technology. I farm in Fairfield with my wife, Beth, a recently retired elementary teacher. We have 4 adult children and 6 grandchildren. I'm in partnership with my 2 brothers, Lawrence and Michael, my 3 sons and 3 nephews on our dairies. We have 4 medium-sized dairies in Franklin County and substantial maple operation, which is going full steam ahead as we speak. We have around 1,400 milk cows and 800 or 900 head of young cattle. We crop around 3,400 acres of land in Franklin County. We have land in Missisquoi and the Lamoille River's watershed. Staunch environmental practices have been a rule of thumb on our farm for decades, long before accepted ag practices and RAPs were common terms in the industry. Our land's a little bit hilly, a little bit stony, and it can be wet up here in Fairfield. Tile drainage has been a tool we've used for decades to prevent erosion and increase productivity on some of the land that needed it. I'm very supportive of S45 as it's written today. Certainly not an attorney by any means. Was asked to testify here and tried to get up to speed on what has been going on with this bill, and I'm really not where I'd like to be, but in simple layman's terms, it appears to give us as a dairy farmers or crop farmers the same protection that every American lives by, as innocent until proven guilty. It shifts the onerous to the plaintiff from the farmers to prove there has been a violation of practices, and we certainly would support this change. Our industry has many hurdles to overcome, a lot of uncertainty every day. A lot of it, as previous, as Mr. Rich said, is the weather. We live by the weather. Nothing more prevalent than that than the maple season. A few degrees here or there can make the difference between a full crop and one not so full. This year, Mother Nature is doing okay here in Franklin County, but I think in other parts of New England, they'd like to have a little different take on it. But we take what we get, and in the dairy industry, the weather plays a big role in how we operate, and we do our best to comply with the standards that we have to live by. As far as the trespassing part of this bill, that the attorney, Mr. Groman, I think, spoke against, I guess I'd prefer to have the trespassing part stay in. He went into length about the apparently water and pesticides trespassing, but I'm looking at it more as a physical standpoint. We own and operate a fair amount of acreage, as most dairy farmers do, and trespassing can come in many forms. It can be hunting, it can be snowmobiling, it can be four-wheeling. There was a case here in Franklin County many years ago where a hunter on a person's land without permission stepped into a telephone pole hole where the line had replaced poles, and the hole was there, and broke his leg and tried to sue a landowner. There have been other instances where snowmobiles have run into drainage ditches or fences. And so some of these things may not be anybody's fault or negligence, but usually who's ever culpable are the ones who are the most resources or best insurance. So I think the onerous and all these should be on the plaintiffs and not on the farmer for being there, I guess, for lack of a better term. The dairy industry has changed drastically since I've been farming, and how we adapt to changing landscapes, changing markets, trying to grow, to be efficient enough to bring our family in if they want to farm full time, or just to generate enough income to stay in business, as maybe the outside world hasn't kept up with what we need to do. Vermont has grown in population maybe 40% since I've been farming, and a lot of people don't understand what we do. And with the event of work from home and high-speed internet, there are many people moving into Vermont that don't understand what we do. Some of them moving in sight unseen after COVID, and they may end up in a place that looked fine in the fall and winter months, but maybe by spring, it's not really what they envisioned. So I think this bill tends to alleviate a lot of the stress on the dairy industry by giving us protection for doing the things that we do every day and have done for decades. Attorney Groman spoke at length about water quality. I guess as a dairy farmer, the RAPs are all about water quality. Everything we do is about complying with environmental standards to protect our waterways, whether it's, the buffers, the cover cropping, the tillage, the nutrient management, how we feed our cows, our bunk silo management, the equipment we run. It's all around water quality. And so I don't understand why he didn't want to see that. And the other point, and I should stop rambling and let you have questions. The other point I've just seen, that I wouldn't want to confuse this bill with there's a little bit of a power struggle between ANR and the Agency of Natural Resources right now. And I guess and the dairy industry is kind of caught in the middle because we don't know who's going to regulate us. And it doesn't seem like either group is showing all their hand because we can't really figure out what's going on. But this bill really should not get wrapped up in that. I call it a power struggle. I think we should stay aside from that and do what this bill intends to do. I think at some point, one side or the other will prevail in our jurisdiction, and I hope it's the Agency of Ag, as we have been working with for many years now. I guess I'll stop there and see if we have questions, and I hope I was somewhat clear. So I'm kind of new to this, but
I think that's been very helpful. Thank you, Harold. So Tom Oliver has a question.
Hi, Mr. Horgan. I guess my question would be around, I get, we understand the water side of it pretty much is being targeted a lot. But the trespassing side, I'm trying to think of things that you might be concerned about. As a farmer, you utilize a lot of land, a real lot of land, more than most people do. And no matter how many surveys you do, things like that, sometimes you get property lines a little bit wrong. May not be by a lot, but a tree could come down that wasn't yours, or a tree could get tapped, or a fence line put up. I mean, no innocent things. I'll meant to be innocent, but it could cause somebody some potential loss. How do you feel about that? Is that a common thing for you?
I think a lot of that, would just be a neighborly interaction could solve most of those issues. And I think we always have striven to be good neighbors with everyone around us. I would look at the trespassing part as more of a, agrarious situations where, something happened on the land that really wasn't a force of nature. And the other part of the trespassing, when Attorney Groman was talking about the water and Mr. Rich talked about the storm last year, I think when we think about Mother Nature and living in Vermont, obviously with the hills and valleys, and streams, water trespassing onto your neighbor's land downstream, that's out of everyone's control. So I think that's probably where we need protection, probably more than the physical part of the actual trespassing, because, we live in a time, probably the storms are a little more severe. I think there's certainly more focus on the storms. I remember some equally as severe in the 80s here that, did much damage as any of these recent ones, but there certainly is a focus on them now. But the one thing we can't change is the weather. We can just work with it. So I hope that answered your question.
Yeah, it does. Thank you.
Other questions? I don't see any other questions, so we'll let you get back to enjoying this beautiful weather out there. Speaking of weather, and we're trapped in here for a little while longer ourselves, unfortunately.
Yeah.
But I appreciate it. I appreciate your time.
I would just want to thank each and all of you for taking the time to look at this bill as it works for the system, and we do look for a better outcome in the end. And I appreciate all you're doing.
All right, appreciate that. Thank you.
Thank you.
All right, so we'll go with to Steve Collier next. If good. And I'll let you start with any kind of comments from what you've been hearing, but then I'm sure we'll have questions as well.
Great, thanks.
Good afternoon.
Steve Collier from the Agency of Agriculture. I feel like every day I come over here, I hear people bragging about how they're not a lawyer. Start to feel a little self-conscious about it. I was hoping to hear a good April Fool's joke today to share, but I haven't. So maybe you all can share one at the end. Really want to thank you very much for taking such a careful look at this bill. We've really been working on this a long time. We think it's really important to farmers, and while it may be out of the normal sort of scope of your work, we really do think it can make a critical difference. So, and farmers are legitimately very concerned about it, and I think with good reason. And if we can provide farmers a little bit of comfort that they can know that if they're doing things appropriately, they'll be less vulnerable in court. That's one of the few things they may have a little bit of control over is their own actions. And so if we can help them understand that if they're doing things within the scope of the law, they're not as likely to be successfully sued. That's at least one thing they can maybe check off their list a little bit, because when they're dealing with labor issues, or they're dealing with weather, or they're dealing with commodity prices they can't control, there's a lot of factors they don't have any say in. But if they're doing everything to follow the laws that you all are requiring of them, they ought to have some comfort that they enjoy some protection while doing that. So I want to talk a little bit about the idea that it's okay to make the farmers prove their innocence because it's special treatment under the law. I just want to give that a little bit of context, because it is special treatment, but it's quote unquote special treatment that all 50 states give. So, and the reason for that is farmers are in a very unique class of people and that they feed us. So there is a pretty significant public interest that they're successful, because without them, we don't eat. So it's very important that we have clean water, but it's also very important that we have farms. So it's not like this legislative prerogative to give them special treatment came out of nowhere. It's because what they do is so critically important. And they're really, I can't think of another class of people who use their homes, their land to do their work. So they are, using they're using their land actively to produce that food. And with that use come collateral consequences. If you have manure, it's going to smell. If you're plowing 300 acres, there are some potential collateral consequences to that. So while it's quote unquote special treatment, it's well targeted. There aren't, the rest of us who go to our office every day, or go to the store every day, or go somewhere else, we're not using our land to generate something that's for everyone. So I don't think that special treatment is misplaced. In fact, I think it's there for a reason. And when you think about Vermont, we're a rural agricultural state. We also have some of the strictest environmental regulations in the country, and that includes for water quality. And those are important. Everybody in Vermont, and farmers included, value our environmental protections. But we are also a farming state. And when you're a rural farming state and you have one of the weakest right to farm protections in the country, that's worth looking at. We do have a weaker protection. And I think it's really important to think about why that is. And the reason, and I don't know if Mr. O'Grady told this committee or not, but I've heard him explain it to other committees. This law was last amended in 2004. And prior to that, I think it was in 1998, the Iowa Supreme Court had a ruling that was based on a very similar right to farm statute that we had. And the Iowa Supreme Court decided that the nuisance protection was a constitutional taking. And because of that, there was concern that the application of that would result in constitutional infirmities. And as I understand it, the Vermont legislature back in 2004 took a look at this and took a look at Iowa Supreme Court's ruling and decided we need to be careful here. We need to make sure that we create this statute and balance it so that there's not a taking. And so that's why we have this convoluted framework where the farmer has to prove they've done everything right. And then even if they do that, the plaintiff can overcome that presumption. The noteworthy part about that is every other court in the country that's considered this issue has repudiated the Iowa Supreme Court's judgment. So as you heard Professor Echeverria say the other day, he does not believe that there is any risk that nuisance protection is a constitutional taking. So essentially in 1998, the Iowa Supreme Court issued a judgment, which every other court that's considered has disagreed with. But because of that 1998 decision, we have a statute that's based on a fear of that decision, which has been repudiated everywhere. So if our statutory underpinning is based on a constitutional interpretation that's flawed, it probably makes sense to revisit it. And I think that's why it's so important to do that. It made sense, I think, at the time when the legislature was looking at this issue in the Iowa Supreme Court, but I don't think it makes sense now when we know that's not a real danger. And even Iowa itself has significantly backtracked off the decision that I don't know that it's completely repealed it, but it's repealed the reasoning and it's very different now than it was then. And so the whole grounding of our current statutory framework has been discarded. So I think it makes sense to take a look at the law. The other piece I would say is that this is not about any individual case. This is not about the Erie Point Vorsevold case. It's not about any other situation. It's about the law itself. And when you look at the law, I don't think anyone can look at this law objectively and think that and conclude that it's well constructed. It's not. I mean, if you think about what you'd have to do, if you think about a farm that, say, it has a neighbor a mile or two downstream that's complaining about pollution on its land from the stream and smell. So then that neighbor a mile or two down sues the farm and nuisance and trespass. How is the farm, what laws are the farm supposed to prove that it's complying with to show that it's entitled to the rebuttable presumption? What's the scope of that complaint? Is it everything on the farm? Is it just what's discharging into the water? Like, you can't even define what it means to show that you're complying with every law, but that's just the first part of it. Even if you can figure that out, then you have to move to the next step, and you have to show that the farm, again, this is the burden on the farm. They have to show that they're complying with good agricultural practices. Again, like that probably requires an expert. And again, the scope is unclear. Good agricultural practices for what? Is it for everything happening on the farm? Is it?
Let me add on that one. I mean, I certainly want you to keep going, but it seems that that's really a red herring as far as, I mean, it would be what is relevant. I mean, if it's a water complaint, you're not going to look at the smell of a sewer, or not sewer, of the manure. The case will define presumably what is relevant. You don't have to show that they're in compliance with labor laws and all that, right? I just want to make sure I understand where you're coming from on that.
Well, I mean, that's a great point, but in generally speaking, right, when a plaintiff bears the burden of proof, then the plaintiff is the one that's alleging things and the defendant is responding to those allegations. This is quite different, and that the plaintiff can just say, you're polluting my land and then your manure stinks. And they don't, if they're not put to the burden of proving what the farm is doing wrong, then the farm is arguably has to assess its entire operation to prove that it's doing everything right. Maybe it's got too many animals. Maybe it's got a manure pit that's leaking. There's just if you don't put the onus on the plaintiff of proving what's wrong, then you make the response really difficult. That's why the burden of proof is so important, because when the plaintiff bears the burden, they have to say what you're doing, and then the defendant can still respond to that. But if you're just saying, and in discovery, facts change, right? So you might have some facts at the beginning, and then a year later, the plaintiff files an amended complaint or changes their facts, and then the whole scope can change. And every time, if the burden is on that farm to prove their compliance, it's just a really unwieldy standard. But those are the easier ones. The surrounding non-agricultural activity and the proof that there's no significant change are much more difficult, because so in other words, you have to prove you're following the law and good agricultural practices, but also you have to prove, the farm right now has to prove that they were there first. First compared to who? If somebody's 2 miles down the road, does that mean you've got a 2-mile radius around the entire farm? Is it just downstream? And how can you ever, looking at property development in Vermont, how can you ever prove that there was that you were there before every activity between you and the neighbor? Or is it between everybody in that vicinity? Or is it only the neighbor who's suing you? It's a standard that makes it impossible to know what you can do and can't do.
Yeah, so I can definitely see the standards need some work, but it still seems to be pushing the argument a little bit too far. When you are bringing a nuisance claim or a trespass claim, you have to provide certain facts what the nuisance is, what the harm is, et cetera. There would be something one would be responding to. But I take your point. This is a little broad. It could be definitely worked on, but I don't think it's quite as bad as the farmer has to prove everything's pristine on their property when they're responding to a trespass involving excess water coming from a tile drainage in the one instance that we know about. But anyway, I know that Ian and Karen had the hands up as well.
Just very briefly, so the burden being on the farmer is just to get the presumption. If they failed and they didn't satisfy that burden, the burden then would still be on the plaintiff to go through a nuisance or a trespass claim and show the damage, show the impact, and go through that whole process anyways. They just don't get the presumption, right?
Correct. Right now, the way it is, the plaintiff just has to show there's an interference with the use and enjoyment of my property.
For nuisance.
Yeah.
But for trespass.
For trespass, they have to show there's some sort of physical invasion of their property, which they argue can be both particulate form or an actual physical invasion.
And that they've been harmed.
The land, not them, the land.
But the land's been harmed.
Yeah.
Yeah. So I think just when we're talking about burden and who has the burden, the presumption that I like under the current law, that is on the farmer, or on the farm owner, but that the plaintiff still has a burden here to have to prove, especially with the trespass, which doesn't even exist within this framework at the moment. So, right, there is still burden on the plaintiff.
Of course, but there's zero protection for the farm that's distinct from any other property owner unless the farmer can prove that they're entitled to the presumption. So there's zero protection for farms under the current right to farm law unless the farm can meet each one of those criteria. So in the legislative intent, the legislature says they want to protect farms. If the farms don't meet all of those criteria, there's zero protection. They're just a regular landowner. So if you want to protect farms, arguably this isn't the way to do it. To make them show that they're entitled to a presumption because nothing about their operation has changed, significantly changed. I mean, that's kind of the death knell. You just heard Harold Hourigan, who's a wonderful farmer in Vermont, testify. They're changing all the time. They have to, or they're not going to survive. I mean, when you've lost 32% of our dairy farms in the last 5 years, it's pretty obvious that change is quintessentially important. We encourage change. We promote change. Most of that change is beneficial, including for the environment. Things like going from, no-till to which means you're not disturbing the soil, so you have less erosion, and things like injecting the manure instead of spreading on the top so it doesn't run off. Those are really beneficial changes. Under the current statutory framework, a plaintiff could say, wait a second, that's a significant change. You're now injecting your manure. That's not what you did 20 years ago. You're not entitled to the presumption. And the court, if it's reading the statute and applying it, might have to agree with that. I mean, that's an absurd result. Why would we want to tell farms they can't change in a beneficial way? And if they do, they lose this nuisance protection. That just doesn't make sense.
No, that's definitely the case. I mean, it should be tied to significant change is what has caused a nuisance or trespass. You're right, the law doesn't say that, and that should definitely be clarified
Yeah.
if that's anything that's going to continue in here. But yeah, the language as it is does have problems with that. But Karen.
Yeah. So there's a couple of things for me. Like, I agree that we could tighten up language of it. I guess there's a couple of things because you are saying like, if there was some kind of nuisance claim of that, a farmer would have to check, and you said like a leak in some equipment, or was it this, was it that? And I guess there's part of me that I think farmers would want to be on top of all that, to know all those pieces. And so it shouldn't necessarily be a burden, like that should be common practice. And so I also want to see if this comparison works, because I understand the piece of that farmers are doing a lot for our communities, for our state, and they're using their land. And I'm trying to find some similarities. And so I was thinking like home childcare providers, they use their home, their land, home bakeries and do that. And they have certain practices that they have to follow and use. And isn't that what we're asking our farmers to do? Like, you're signing up for this job, you need to follow these rules to do that. And the assumption is that you're following all of that.
Well, a couple things there. One, I would say that the way that the S45 as proposed absolutely is requiring farms to follow the law and the rules that you've all set for them in order to get the benefit of the nuisance and trespass protection. So absolutely agree. There's a similarity there. What we're saying is if farms are following the law and they're also following proper accepted customs and practices, then they shouldn't be subject to a nuisance suit because they're manure sticks. In terms of the analogy to a daycare, I mean, farms are farming anywhere from, small plots of land to hundreds and thousands of acres of land, not too many that are in the thousands, but some. So I don't know that, I mean, a screaming kid can be pretty annoying when they're out on the swing set, but I think that's more of a municipal zoning issue where, municipalities are actually determining what kind of activities can happen in what areas. And I don't think a child in a swing is as likely to generate a nuisance claim as a farm with 1,000 cows.
But couldn't you say the zoning thing is also the same for farming?
Well, farms are not subject to municipal zoning when they're only farming. They are subject to these required agricultural practices, which are part of the water quality requirements. They're subject to other regulation by us, by ANR, by DPS, depending on what they're doing. And they can be subject to zoning or Act 250, again, depending on what activity they're doing. So there's a whole overlay of regulatory requirements, but when they're strictly farming, they're not subject to municipal zoning.
And then my last question, and you might have heard this is the theme, I'm trying to understand the data that's leading to all this, because I agree that we don't want to have farmers inundated with these types of.
Right.
My understanding is that that's not happening right now. Do you have data on the number of nuisance claims that are going out, or the number of farmers that are choosing not to come to Vermont because we're being inundated with nuisance claims?
I'm not aware of anyone not coming to Vermont because of nuisance claims. I'm aware of a lot of farms you think about going elsewhere, including to New York. And I'm aware of a lot of farms that closed down. I don't think it's ever, or at least in my experience, it's not specifically because of a nuisance claim, but it is because of a lot of pressures, most of them financial. But this is one of those areas where farms do feel a real threat. And that whole premise that it's not a problem because no one's getting sued, I think it overlooks the statute itself. And you can say the flip side of that is, well, if no one's getting sued, then why do we care if we make the law better? To me, it's kind of a cop-out. The people who are asking you to keep the law, like it because it's really good for neighbors. It's not good for farmers. And that's a legitimate perspective to have. If you're not worried about the farmers and you're worried about the neighbors, okay. I mean, I can understand that perspective. But to say you shouldn't fix a law because there aren't a lot of lawsuits, I think is a pretty failed. To me, it's not compelling. If you look at the statute and it's well written, sure. But if you look at the statute and it's not well written, then it ought to be corrected. And in terms of the actual cases, I don't have a way of knowing how many cases, because unless I went to every courthouse and looked through every court docket, you can't know about every case that's filed. You can search for opinions. And there was a time, and I don't remember the exact date, when you couldn't really find superior courts or trial court opinions. Now you can find most trial court opinions, but it doesn't go back forever. And you only get an opinion if there's a decision. So a case can be filed and you can settle it, and there's no document that you can easily find in a legal database. What I can tell you, in the last 22 years, so from 2003 to today, there are 4 different nuisance right to farm cases that have gone all the way to the Supreme Court. So that's not nothing. In 22 years, on average, every 5 years, there's a case that's not only being filed in Superior Court and where you're going through the trial or the motions and doing all that work, it's going all the way up to the Supreme Court. So, and if you look nationally, there's all kinds of cases. I mean, this happens all the time where people don't like what a farmer's doing and they file suit. So,
For those 4 ones you said went to the, what were, the filing, what were the outcome was?
There's 2 that involved Trickett and Oaks, or a farm down in, I think that was in Addison County. And those were 2 related suits. And one time the farm won and one time they lost. There was another case that was, I think I want to say 2008, that involved pesticides, where somebody, a developer claimed that a farmer with the orchard sprayed pesticides, and that was a trespass and a nuisance. And the Supreme Court ruled on that. And then the more recent case that you've all heard about with Area Point and the Borstveld. So, but I will say, in my experience in 5 years at the agency, like I'm aware of right now, many cases that could go to a nuisance claim. Doesn't mean they will, and probably they won't, hopefully. But there are real conflicts between farms and neighbors. And no one from our agency or that I've heard testify is suggesting that farms shouldn't be doing things appropriately. They should be held to a standard. It's just that they are held to a standard, but by us, by A&R, by others. And if they're, and neighbors have every right. No one's suggesting a neighbor shouldn't have a right to bring a suit. But the question is, who's drawing the lines? Is it the legislature? Is the legislature drawing the lines and say, this is what we can expect from farms and this is what we can't? Or is it individual neighbors and individual courts? And if you've ever met a human, you can understand they're pretty different. And that's just the same with judges. So you can get, we have this one judge who ruled this way, and another judge might have ruled a completely different way. And that's our judicial system. That's okay. But if you don't create clear lines, you almost by default get very different outcomes. And ideally, that's not the best balance. Like when I read a law, and most people want to comply with the law, farms included, like I think it's really important for someone to be able to read the law and know what's required. And I've been practicing 30 years. And when I read this law, I don't know what's required. And that's just not, I don't think, an acceptable place to put neighbors or farmers in. If you want to put the burden on the farmer, which I, disagree with as a philosophy, at least tell them what the burden is. Like tell them if you prove A, B, and C. And I don't think that's the right way, because our system is the plaintiff bears the burden of proof. If a farmer kills somebody, the plaintiff has to prove a wrongful death case. Farmer doesn't have to prove they didn't do it. That's just our system. So, and that's important, I think, for discovery too, because it's not, when I think about litigation, I'm not trying to guard against meritorious litigation. I'm trying to guard against frivolous litigation. And if you don't have clear lines, it's much easier for frivolous litigation to take a lot more resources and time. Whereas if you have some clear lines, then you can pretty quickly figure out through discovery whether a plaintiff has a claim. But if you make it on the defendant has to prove it from the start, then the whole system is backwards. And then you're much more likely to not be able to resolve it just on the papers, the motions for summary judgment in front of the court. You're much more likely to have disputed material facts. And so that's just, I don't think that's good for anyone. If a neighbor wants to bring a suit and they think they have a meritorious claim, they ought to be able to assess their chances, because it costs a lot of money for them too to go to court. So it's not a, that's how I look at this. If you've got a meritorious claim, you want it to proceed successfully. But if you don't, you want to let the farmer out as soon as possible. Or if the farmer messed up and they know they messed up, hopefully they have the incentive to settle it early rather than litigate it. Like, because they know, oh, geez, I was violating the RAPs. I violated my, my nutrient management plan, whatever it is. So maybe I should just try to make this right instead of spend 3 years, fighting it. And that's part of why the mediation is helpful. It's just to try to get folks talking, because our society's not as quick to walk across the street as we used to be and say, hey, what about this? So
you good?
Yeah.
Before I go to Ian, so I agree the language in the current law needs to be amended.
Yeah.
I mean, it is not clear. We've had very good testimony to that effect. But whether this is exactly, there are some big questions on whether this gets us all the way there. And one of them is the requirements of the RAPs. And that's not something you did say that, the farmers are following the law that we set for them. No, not really. It's following the law that the agriculture department is setting for them. And I guess the question I have is what are the water related RAPs that farms are subject to at this point? I mean, where do we see those and how do we understand those? And answer that question first.
no, it's a great question. And you're right. We create the rules, but only with the express authority that the legislature has given us to do that. So we've drafted rules in the way that we were told to do. And the rules are very comprehensive. I mean, I'm happy to give you a link to our website or to the actual site on there. But they're very expansive, and they cover things from farm structures and location of farm structures to, mostly they're designed to prevent waste from runoff. And they mirror really the Federal Clean Water Act. The whole premise of the Clean Water Act is to protect water by ensuring that farms aren't discharging to water. That's federal law. The Vermont legislature basically extended that whole framework to the state and said, not only can you not discharge to water, but we're going to set up this whole universe of regulations where farms are required to prevent discharges. So that's the whole point of the RAPs and all of the water quality regulations is to do everything possible to ensure that farms aren't discharging. And a lot of just kind of two ways you do that. One is by controlling the production area, because that's where the greatest risk of waste is in the actual area where the animals are, the feed is, the manure is, like all those areas are production areas. And you can't have water from going through those production areas and then reaching surface water. So there's a lot of it's designed to make sure that surface water runoff from production areas is stored and not just diverted to water. Then there's also field applications. So most farmers, at least who have manure, and other farmers are also spreading fertilizers to make sure their crops grow. So there's a whole series of regulations, and there's kind of modeled on federal law where it says that you can spread your manure, but you have to do things like have a 25-foot vegetated buffer on surface water. So when you're spreading in the field, there's this 25-foot vegetated buffer. And the idea of that is it's going to prevent runoff from going into the stream that's nearby. It's a very comprehensive, there's a nutrient management plan that farmers have to do is 300-400 pages long sometimes. And the whole idea of it is to make sure that they're spreading nutrients in a way that doesn't oversaturate the soil, so that the soil can properly absorb and the plants can use those nutrients rather than them all running off to water. So it's a comprehensive labyrinth. And I totally understand that without that background, this might look a little naked on its own. But when you bring in those regulations, then you start to see, well, wait a second, this is covered. And so if a farm is doing all of those things, and that's part of the reason I think, it's really not that hard for the plaintiff to show if there is a violation, because there's all these rules that farmers have to comply with. And if they're not, then the plaintiff is going to be able to show that. But to instead say the farmer has to prove they're doing all those things right without even necessarily knowing whether there's a causal nexus, that's tough So yeah, those are important to the whole underpinning of this. But even then, even with those, there's still there's still a common, the proper and accepted customs and practices. So I mean, I think the coverage as designed is pretty comprehensive, that if a farm is not doing things appropriately, a plaintiff is going to have a claim. If a farm is doing everything appropriately, they shouldn't.
Ian.
I think only push back is the right word,
Please.
but I appreciate
Your
your
attorney that went to Michigan.
Yeah, and you're an attorney, you're doing your job, and I appreciate it. I just think if I read the plain language of the purpose of the title from the existing law.
Yeah.
It's the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. So it's a deterrent lawsuit, or it's a deterrent statute, right? We want to deter people from filing nuisance lawsuits against farms that are conducting reasonable agricultural activity. And so if that's the case, why shouldn't we as a legislature consider the fact that there haven't been very many, if almost any, nuisance lawsuits against farms as rationale for this statute to be effective?
That's a great point, and it may have deterred. I can't. You don't know what you don't know, and it's possible that people have read this statute. Especially if I were a plaintiff and I read the purpose, I'd be like, oh, I guess I can't sue. And that's actually the first time that I read the law. That's what like, oh, this is pretty good. And then I got to the part that matters. Like, what is this? So it probably has deterred some suits, but I don't view the statute as a deterrent. I view it as a protection that's not in any way intended to be absolute. Instead, it's important to have deter people from filing suit, but if you get sued, it's even more important that you can prevail if you're doing everything right. So I think it's more than a deterrent. To me, it's setting the ground rules for what's acceptable, what farms can do and what they can't.
Well, and I don't disagree with that at all. And I just think that if we're talking about frivolous lawsuits, and I think that a frivolous lawsuit still costs someone money.
A lot of money.
A lot of money. And so while protection is key for frivolous lawsuits to dismiss them, even more of a protection is keeping those lawsuits from happening in the first place, because you don't want to tie up people in court and spend their money. So I think like the deterrent is an element of protection.
Agreed. And I can guarantee you that if you passed S45, the deterrent would be more significant than it is right now. Because if you got a lawyer to read S45 versus the current statute, the lawyer's going to say, if you want to bring this suit, you got to prove the farmer's doing something wrong.
Yeah.
Which is a whole different ball of wax than what you have right now. Right now, you just have to, all the plaintiff has to prove is they don't like what's happening on their property, that it smells or whatever it is. They just have to talk about their property. They don't have to show the farm's doing anything.
Just one other quick question. We've talked a little bit about other states and their right to farm laws. Are there any in the Northeast that you like that we could look at? We got, I think, from Ledge Council, we got some last week in testimony from Kentucky, Michigan, and Oregon, example language. But we've heard some discussion and gotten some testimony about how like it doesn't align with what we're proposing. S45 is really aligned with other things in the region. So I'm just curious if there's other language from a more regionally close neighbor that you like.
That's a great question. And I haven't thoroughly read all the different state statutes. And when I was reading them, it was several years ago, but I did. I spent quite a lot of time consulting with folks, including Mr. O'Grady several years ago. And we didn't come to this S45 language lightly. And it's Vermont specific because it's incorporating rules that apply to farms, but then it also has this broader protection for the accepted customs and standards. And then it also incorporates the negligence provision, which is again a neighbor protection, where it's saying even if a farm does everything right, if they do it negligently, that's not good enough, which those are opening the door for plaintiffs. And I fully appreciate that. But we're trying to balance those interests, not just saying a farm can do whatever it wants to do. So I actually think the current language is really quite good at setting the rules. It's not perfect because proper accepted customs and standards is open to interpretation. And if I were just taking a farm focused perspective, I'd say, let's discard that. But, we understand that balance is part of your job. And so we were trying to make sure that that there's an opportunity for a wronged plaintiff to bring a successful claim.
You good? Ken?
If I'm hearing what I think I'm hearing, obviously I stepped out for a while, but most of the complaints that are happening, as far as I can tell, are happening on the borders of the Lake Champlain, right? It's not like the Winooski River going up through there and when we get flooded and all that runoff and all that stuff. Am I right with that? It's like the farms that are bordering the lakeshore property owners.
I mean, that's the case that we've talked about and that you all have talked about in here. That's the one, the most recent
Right.
claim. But I would say that disputes with farmers are much more contingent upon their neighbors and whatever activities are happening than where they are located.
But is there many of them? Is there
Not,
complaints?
yeah, there are a lot of people who call us and complain about farms. And when they do, if it's within our regulatory authority, we go out and we inspect. And if we think there's a violation, we enforce on it. There's also a lot of farmers who complain about their neighbors. I can think of, I'm sorry, who complain about, sorry, I meant to say there's a lot of neighbors who complain to their towns and want towns to do something about it. I mean, I can think of 4 or 5 cases right now that could easily result in a nuisance claim tomorrow. They probably won't. But there are a couple of ongoing and recent related zoning issues where neighbors are claiming that a farm can't do what it wants to do because it's not farming, and those go to court too. So that's kind of the thing. This is just a property claim. Like farms can be sued for all kinds of stuff, and this has nothing to do if a farm injures somebody. This has nothing to do with that. This is just nuisance protection and potentially trespass protection. So, I mean, farms can have an Act 250 complaint violated against them. I mean, levied against them if they're doing some kind of development that's not farming. They can have a zoning claim brought against them if they have an accessory on farm business or if they're doing something that's not farming. They can have a personal injury action brought against them. They can have any number of things. This is just a very narrow function, but it's important because farms do have some collateral consequences. So the lake it's just one example, but the bottom line is if a neighbor doesn't like how the farm is impacting them or just doesn't like the farm, this is the law that defines those interactions.
Right. So it's kind of neighbor against neighbor. But what I'm trying to get at here is farmer is like that 25-foot buffer that you're talking about, right? I mean, a farmer doesn't want the material that he's spraying or any of the manure or anything to go off his land. He wants to keep it on their land or his or hers, whatever you want to say. You don't want that spreading somewhere else. So they're going to do their due diligence to go and keep it there.
If they don't, they can be enforced against by us. They can also have A&R come out and say they need a what's called a federal NIPDES permit, a CAFO permit. They can also have a citizen file a suit saying you're polluting to the river. So under the Clean Water Act, they can bring a neighbor can bring, or an environmental group can bring an action under the Clean Water Act. So yeah, you're right. They don't want to be discharging to water because if they do, they're vulnerable in a number of different ways.
So getting to my point of this whole thing, my question is you have all this water, like certainly the aerial view that I'm seeing of certain farms and stuff like this, that you got all this water that's coming from all these other areas, especially in the flat areas up there and certainly in the mountain areas here where we really don't have the farms anymore, right? You can't control that with the amount of storms that we've been having the last couple of years. I mean, how do we even begin to deal with that and make it fair for everybody?
You mean stop water from running downhill?
You had to put it like that.
Well, yeah, it's a conundrum. I've never seen, absent a dam, I haven't seen people be very successful at that. Yeah.
Good, Ken? It's just so following up with that was one of the questions I wanted to kind of pursue. I had a couple. So with the new weather events that we're seeing, I think we've had a couple of our witnesses mention that there required agriculture practices that are being changed that is going to put more onus on farmers to deal with the fact that they're going to have a lot more weather events and they need to do something different for their fields? Or is it that's just an act of God? It's an unusual event and there's not really a ground for trespass because water runs downhill. I mean, there's a kind of
Yes, and there will always be a push to make the requirements higher. I mean, that's just that's reality. And so the most recent revamp of the rules was in 2015 or 16, 16, I think. 16, thanks. So that was a very significant change. A lot of people dubbed it, I think it was Act 64 in 2016, the Vermont's Clean Water Act. So that revamped the framework pretty substantially, not very long ago. We've been recently asked to up the standards and we respectfully declined that. I mean, the legislature can always do that. We're always open to if there's something that's not working right now to considering how to do it better. We're focused. We think that the current framework is quite comprehensive and successful. The challenge is to get everybody into compliance.
And so therefore, if there are these big weather events and there's extra runoff and such, the farmers are not facing liability for trespass in that kind of situation, presumably.
Well, they are. I mean, not from, well, a nuisance or trespass claim by a neighbor. And I mean, the court can choose to say it's an act of God and it's not actionable, but that's up to the judge right now. Our agency is not enforcing if there's a flood and someone has a discharge because of that flood and they're properly equipped. Like they have to have a lot of standards, including they have to be equipped right now just to be able to survive a 25-year, 24-hour flood event. So floods are categorized based on the severity and they're done by years. So a farm has to be equipped to be able to withstand a 25-year, 24-hour flooding event without a discharge. If they are properly equipped, and then they have a 50-year flood, then we're not going to bring an enforcement action. But under the Clean Water Act, someone could. And under the nuisance claim, someone could. I'm not saying it would be a legitimate.
Yeah, it wouldn't be a very good claim.
No, but nothing stops.
Anybody can bring any case.
Sure.
But I'm looking at like a case that would be reasonable. And if there's a 100-year flood, bringing a trespass claim against a farmer should get you a Rule 11 sanction, frankly.
Well, you'd hope.
Yeah, you'd hope. But so my other question is, so under this language in S45, let's take a scenario where we've had some developments near a farm because we're trying to build more houses, and we do have that near a farm, and there is standard smell, and you can't sue them for that. Well, you can sue them, but you presumably shouldn't be successful if there's the standard farming practice that is occurring at that time. But then sometime down the road, and other accepted customs and standards or RAP or whatever is implemented, and all of a sudden either the aromas, the bad smells, or the water or something else has increased significantly. It seems like this would still cover that farmer if it's a standard practice elsewhere, even if, this development occurred when none of that was happening. And now the development now there has been a change in farming practices that has that impact. And it would seem that this would still protect farmers in that scenario.
So you're saying the farmer changes its activity.
And the activity is still fine under the RAP or under the accepted customs and standards. It's fine under those standards, but it now has a much more significant, I guess you mentioned collateral consequences, which I kind of want to understand what if those collateral consequences are significantly changing the impact on that development. It seems the language right now would allow this presumption would allow the block of that trespass or nuisance claim.
I think that's right. I think the design, from my understanding of S45, is that if a farm changes its practices, recognizing they have to diversify, they have to change their practices, they have to stay kind of on top of new developments, as long as they are complying with whatever standards there are at that time. So the standards may change and the standards may get greater, But if they are complying with the standards in effect at the time, then they would be entitled to the protection. Yeah.
Which this seems to be a substantial change from the current law. And the current law supposedly is looking more at people moving into near a farm and then suing them for what's going on at that time. Is that not correct? It seems like a substantial change from current law.
It is a substantial change from the current law. I think the biggest change from my perspective is the rebuttable presumption with the burden of proof on the farmer to the burden of proof on the plaintiff. The changing activities, farming changes and what you do, that at least in Vermont, where we've primarily been a dairy state, which is where most of the complaints come from because of manure. And, most of the other farming is a little less likely to engender complaints. Not that it can't, and it does. But if we suddenly changed everything about our production and we went to a hog farming state, I could see some changes, and probably our rules would have to evolve to accommodate those changes. But if you're talking about similar type of farming and just changing how you conduct it, I don't think the collateral risks are likely to be significantly aggravated.
Well, and that would be fine. Yeah, if there are no collateral risks, that's fine. But if there are significant collateral consequences that occur because of a change, I don't see taking away the opportunity to just have to prove trespass and nuisance from that, my hypothetical development.
Well, understood. And I think you still always have the custom and standards. So if it's something new and no one else is doing it, then maybe it's not a custom and standard of similar operators. But that's also how the law changes. You got to, from my perspective, right now we're talking about a Vermont that used to be dominated by farmland, and now it only has 9% of its land in harvested cropland. So what you have is neighbors encroaching. It's a bad word maybe, but neighbors are coming closer to farms. Instead of everybody being farmers, there's fewer and fewer farmers that we all rely on, and there's more and more neighbors. So I think right now the balance is, how do we make sure we don't lose all of our farms? But if farming changes in a way that the consequences are unacceptable, then that's, I think, an appropriate time to talk about changing the regulations, perhaps revisiting the statute. But at the moment, the pressure is on farms going out. We've lost 5% of all of our farmers in the last census period, lost 11% of our harvested cropland in the last 5-year census period, 32% of our dairy farms in the last 5 years. All the pressure is on farms. If it flips and somehow farms are driving neighbors out, maybe we have a different discussion.
Isn't most of this development coming from past farmlands?
I don't have statistics on that because we don't map all the changes, but farmland is often the easiest to develop because it's cleared and it's flat and it's there and it's available. There's infrastructure. So there's tremendous pressure on farmland.
It doesn't take a genius to go and drive around Lake Champlain and see that it was farmland and now it's being turned into really nice houses and all that stuff. It's.
Yeah, one of the great ironies why I don't understand, I very much respect our environmental advocates in the State House and respect what they do. I don't understand why farming isn't more embraced, because farming is, generally speaking, much better than development for the environment. And we just happen to need it. You can't not have farming. So why not? I feel like there needs to be a better balance between ensuring that we can have both without prioritizing one over the other. If Vermont, we could become a conservation museum. It's only wealthy people can visit, but
Well, we're not far from that.
but I don't think most of us want that. And that's the balance, right? It's also, you can't have a property owner that can't enjoy their property. So we want farming to be responsible and appropriate. And if it is, then we think the farmer ought to enjoy the protection, regardless of whether the manure pit stinks when they're agitating it.
Key word is balance. Somehow or another, we gotta get back to balance in this state. Going back,
Yeah.
you said something, rule 11 or rule.
Yeah, it's just if a frivolous lawsuit, the attorney can be sanctioned if they file a frivolous lawsuit. And I was
Okay.
suggesting that that scenario would have been a frivolous lawsuit.
Okay, thank you.
Yeah. So does this also mean that we need to tighten the Act 250 restrictions to reduce development of housing? I'm just curious.
Oh my
Because
God.
that seemed to be consistent with what I'm hearing. You're not gonna go there?
Wait, no one?
Not today.
So,
So we want housing, but we don't want housing
right, well, that's what I was,
in our back, in your backyard, or
no, oh, I've been getting lots of housing in my backyard.
Anybody else want to set me up a little?
Yeah.
I'm trying to work in.
Well, I think there's some things to think about here, definitely. And I have had some conversations with Mike O'Grady about a few things that maybe will float to see how they work. But I'm still personally troubled by the trespass, but maybe I could be pushed over on that. I am troubled by there being able to be a significant change in the farming activity that results in significant problems, and that this protects that situation. I don't know exactly what to do with that. I agree fundamentally with the burden shifting, that we need to do something with that, certainly. And I think a little more comfortable of what generally accepted agriculture practices are a little bit. I'm still like to understand those a little bit better, and maybe that's where we get our committee in agriculture involved to look at that. But any other questions for Steve? Because I know that we'll have you back again. I think this is an ongoing thing that we're gonna need to figure this out. Yeah, Ian.
And it may have come out in a question from Martin, but I may have missed it. So we heard a lot of testimony around the getting rid of the trespassing here. Like this is kind of your first rebuttal testimony. Do you have any like written stuff that you could present to us or anything on sort of addressing some of the issues and concerns that were brought up by other witnesses on having trespassing here?
I don't have anything in writing. I could do that if you want, but I do have some pretty simple thoughts on it. If I could share them, I think that I heard the professor's testimony was compelling, on its face that, and obviously what he said, as I understood it, was that the trespass protection would comprise a constitutional taking. The professor was kind enough to talk to me after about it, and I asked him if he'd found any cases that found that way because I wanted to read them. He has not. I've researched it on my own to see if there are any cases where a right to farm protection against trespass has been found to be a constitutional taking. I haven't found any. I found one or two that kind of said the opposite of that. But nobody wants to set up a constitutional infirmity, including us. So I think there's some really easy way around that. And also, I think importantly, the way at least I've been viewing this trespass protection is not that a farm can invade somebody else's property. As an example, go plow their neighbor's field and plant something in it. Like that's not the kind of trespass protection I've been envisioning. Instead, it's that if a farm is farming their own land and they are engaged in activity, that they would be protected from nuisance and trespass. And the reason for that is that almost always when a nuisance claim is brought, it's brought in both nuisance and trespass, and plaintiffs routinely try to cloak them in both terms. And so you can argue that any nuisance is also a trespass of particulate matter or of water or something else. And the courts have evaluated that somewhat differently. The Vermont Supreme Court has not yet come down conclusively over whether a trespass of particulate matter, a nuisance of particulate matter could be a trespass. But the point is to provide protection for activities the farmer's doing on their own land, not to say they can go take over their neighbor's land. But the other piece is, so that could be, I think, clarified.
Yeah.
That the trespass protection is for activities on their own land, but also you can just say, unless they would constitute a taking. Like, so if the plaintiff can prove that the trespass, if the protection was applied, then that would constitute a taking. Sure, absolutely. We don't want to violate the Constitution. So that would be an easy carve out to say it's a protection unless the implementing the protection would constitute an unconstitutional taking. Because that's an important, no one wants to do that, but I don't think you have to jettison the protection because it might. You ought to just jettison the protection if it will. Arguably.
Other questions at this point? Not seeing any. Thank you very much, Steve. And Mike, if you want to join us and touch base on a couple things and cleared and a couple questions.
And thank you all. We really do appreciate the conversation. So thank you.
This is very interesting. This is actually the most interesting vote we've had this year, I think.
Oh, good.
Well, that's great. That's pretty interesting too. Yeah, good point, yeah. So one thing I did want you to address was the taking and the trespass. And if you have any kind of input on how concerned you are about that issue or not concerned, or just kind of enlighten us a little bit more from our objective legislative counsel instead of any advocates we've had in front of us.
Sure. This is Mike Grady with Ledge Counsel. Laws are rarely unconstitutional takings on their face. You have to apply the facts of a situation to the legal test. And there are several legal tests for a taking. The first is, has the government physically invaded the land and taken possession of the land? I don't see that situation here. The second is if there's no economic value left in the land after the state regulation. And I don't see that situation here either. And then to fall to what's called the Penn Central test. It's a 3-part test. You look at the economic expectations of the owner. You look at what their reasonable investment-backed expectations may have been. And then you look at the character of the governmental regulation. And so what courts will often look at is how much diminution is the economic value of a property have because of the state regulation. And there's different ways to look at it. Like sometimes a 60% diminution of economic value doesn't result in a taking. But a 70% does. So it's really difficult to say in any specific case that this will result in a taking. You would have to go through all of that, and a court would have to make those determinations. So I am not that concerned about it, especially when looking at the nuisance claims for right to farm over the years. Steve mentioned the Iowa case. It really was the only Supreme Court case that held that the right to farm law resulted in a nuisance. They have walked it back. They walked it back in a strange kind of way, but they're now giving themselves the discretion to say that claims are not nuisances under their right to farm law.
But that's nuisance. Trespass is a different animal, but
right. But that's
the same.
That's actually a pretty key point, because there's a couple of cases out there where the plaintiff brought every kind of claim that they could bring, everything, and the court would say, no, that's not a nuisance, and the plaintiff would say, well, it's a trespass, and it's like, well, you're just claiming the same set of facts, but just alleging a different action. It's like you're just trying to circumvent the right to farm protection. And in those instances, it's one court, specifically Indiana, said, no, you can't do that. And John Groban referenced earlier that there are 2 states that have the trespass authority and the trespass protection. And that's correct. But then you look at Hawaii, which addresses this specific issue. Nuisance as used in this chapter includes all claims that meet the requirements of this definition, regardless of whether a complainant designates such claims as brought in nuisance, negligence, trespass, or any other area of law or equity.
Nuisance claim has different factors you have to prove than trespass.
Well, so it's an interference with reasonable use and enjoyment of land, including but not limited to smoke, odors, dust, noise, or vibration.
That's nuisance.
That's nuisance in Hawaii, which you could say is the same thing as trespass, from dust, noise, smoke, odors, etc., entering onto the land without the permission of the landowner. So I think that is why trespass has been included in other states. It's there so plaintiffs don't just circumvent the nuisance protection and just file a different claim based on the same set of facts. I understand, never say never. Something could result in a takings based on the facts, but it's much rarer than you would think it is. And with that said, I understand that trespass is novel when compared to other states. It's not the common protection that's afforded. It does raise questions, especially with issues such as water. Some states have language that says water claims are not protected. That contamination by water or contamination of drinking water is not a protected claim underneath states' right to farm. So if you're concerned about water and how it might be unfairly protected, you have options.
Right. That would seem to be like a primary concern is the water issues that we're hearing. I mean, I can understand if somebody's trying to turn the particulate matter from the odors into a trespass, that's one thing. But if it's actual water damage, that seems to be somewhat different. So yeah, that probably is one of the things that I'll try to float in some proposed additional language that we can then have more testimony on. The other thing is that I'm still troubled by the concept, and I don't know if there's an answer to this, of there being a significant change in the practices that does result in damages or nuisance. And
in one respect, it's already in the state's right to farm law, because in the purpose section, it says that farms will have to change and will have to be protected from nuisance suits when they change. It says that in the current purpose law, but it doesn't actually protect that in the existing law. The proposed law would, because it protects agricultural activities, and agricultural activities is defined in Title VI, includes changes, including changes in technique and changes in equipment. And yes, that can change the way that the operation is basically how it has an impact on others.
so, I mean, if you go from having an organic vegetable farm to a pig farm, it would seem to me that I wouldn't want that pig farm is following your practices. That would be a significant change that your neighbors probably should have some rights to oppose as a nuisance.
Well, there are things that would happen before that pig farm could start to be a pig farm. Most vegetable farms, most aren't going to trigger the small farm certification requirement. Some do. But when you transfer to, and I don't remember the Noah's Ark number for pigs that brings you into the small farm certification. But you would then have to annually certify. And if you were over the medium farm threshold, you would have to have a permit. And if you're over the large farm permit, you actually have to get local approval and the Agency of Agriculture's permit. Plus, if you're going to go the way that is being discussed in Senate Natural, there'd likely be an A&R EPA CAFO permit for that farm.
But it still might smell a lot more than your organic farm and undermine your ability to sit out on your back porch.
Right, and that is actually part of the worst of the case that I think scares farmers, is that the court said that the plaintiffs could overcome the presumption in many ways. That she said that they could improve all that was necessary for the presumption. And then she said, regardless, the plaintiffs have shown that it has a significant interference with their use and enjoyment. And what were they doing that was different? And I think that's what scares the farming community. It scares Justin Rich. It scares Harold Hargan. What were they doing that allowed a court to say that it was a significant
You mean the manure pit?
Yes.
Yeah, yeah.
And so they don't think they were doing anything wrong. They think they were complying with their RAPs. They argued that they were complying with their RAPs, and the court said, we don't know that you're complying with your RAPs. You just haven't been enforced against. And so then it really flipped that burden of proof by putting it on the farm to show that they had no enforcement actions, and then they were doing everything else correctly. And then they had to show that there was no significant change. And then they had to show that they were there before. I mean, it really puts the burden on the farm in that situation when it really should be the plaintiff saying, no, they're not complying with the.
Right, well, but that's changing it a little bit. I mean, my concern would be that the plaintiff should have the burden to show that there's been a significant change that led to a significant different negative impact.
So one of the ways that other states do it is they implement a time limit. So the activity's been in place for a year before the act that led to the complaint, and it wasn't a nuisance at the time it was implemented. So it's basically been an ongoing practice that allows change. It allows you to change and maintain it for a year. If for some reason within that year, the neighbor says, oh no, you're not, that is having a significant interference, they can come in and say, you need to change, or you don't get protection in a negligence suit. There are things that other states do to address that. Hey, the farm has to change. It's not going to be able to maintain a profitable operation if they don't change, especially now with the water quality requirements and the ways that the farms are trying to deal with that, either through an injection or moving away from liquid manure, or trying to find other ways to process the manure. Methane digestion, which if you've ever been in a methane digester, your senses come back after like a week. And, you know, do you say, oh, you can't do a methane digester because of the smell and the gas and like, what is the limit?
Right. But I can also see on the other side, the development that moved near a farm that was doing one thing, and then all of a sudden they change, and now their property values go way down because of the impacts. So, I mean, that's the balance we're trying to, yeah, that's a nice point. It maybe makes more affordable housing if they're next door to really stinky farms. It's all tied together, isn't it? All right. The last thing is that, that I have, and if other people want to weigh in as well, if we want Mike to be looking at any other things, is I do feel that should be at least some initial burden on the farmer to at least point that, hey, these are the RAPs that I'm following. But ultimately, the burden is on the plaintiff to show lack of compliance. And we talked a little bit about an idea for that, and we could maybe pursue that as well.
So there are a couple of places in ag and environmental law where in order for a farm to comply or maintain compliance, they have to show that they're in good standing. And good standing means that they don't have a current enforcement action against them, or they are not in violation of a current corrective order against them. And that's pretty easy to prove. You just go to the relevant agencies and say, is this show demonstration that I am not in violation, that I am in good standing? And you're probably going to have to tailor that a little bit. And that might have to change a little bit depending on what's happening in the CAFO bills. But I think I can draft it.
Well, that's something I think it's worth taking a look at.
Can I just
Yeah, go
ask a
ahead.
clarifying question about that? So the agencies don't have the same problem that it sounds like the court was running into. Like if you go, a farmer can go to an agency and the agency can say you're in good standing versus, I don't know if you're in good standing, did you do, you know, like it seemed like this.
Well, in the situation you're discussing, there might have been some, I think one agency said yes, they're in good standing, and another agency said, well, maybe not for everything.
Okay. Okay, but it sounds like the agencies, whatever those regulatory entities are,
Mhm.
have a way of saying, yeah, you're in good
I
standing.
mean, it's an objective. There's a corrective action order, or they're subject to an ongoing enforcement action. I mean, those are two objective determinations.
So if we put these things in, then we can continue to have our discussion and debate about whether people are more comfortable with trespass being in there. I know some people are completely fine with it, but I'm reading the room a little bit. There are people who are not, including myself, but these changes might bring me. Anything else that you want, that folks want Mike to kind of look into for some suggested language to keep this thing moving along? Yeah.
Did you say affirmatively that you're interested in hearing, reading some possible language that would essentially carve out water?
Yes. Yeah. Yeah. Yeah.
So you want to look at carving out water. You will look at potentially changing or enacting like a threshold standard that the farm has to show.
Yeah.
You want to look at potentially changing the trespass language. I can do that.
In what sense on that? Because that's different than taking it out.
You could do something like why did and define what a nuisance is, including fact scenarios, which any person, a plaintiff, to claim trespass on the same set of facts.
Yeah, let's look at that. Yeah, no, I mean, because, yeah, let's look at that and have the witnesses talk about that. Ian, did you have?
Yeah, I was just thinking about for the trespass, with what we heard from Hawaii's law, instead of carving out water, like looping in particulate for trespass in the right to farm. I'm just thinking about if there are other trespasses that aren't water that could be, right? Like, do we want to carve out water, or do we want to try to wrap in the odors, particulate, smoke, things like that into something that could be used in the right to farm?
But I think that's what Hawaii's law does,
Yeah,
to a large part. And there are trespass actions. Steve Collier mentioned one. It was the pesticide drift. And that's why the pesticide control regulations are part of these standards. You have to comply with the setbacks and the weather conditions, et cetera, in order to apply. You're supposed to have vapor drift controls and particular drift controls. And that's why that's there.
Yeah, so I feel a little more comfortable like pulling in the particulates rather than carving out the water. Does that make sense?
No.
Okay.
I can give you both.
That's probably me, not you.
No, just that, that the trespass, if you carve out water as the only trespass that isn't going to apply, there are other trespasses that could be like liquids or other things that if we don't have the carve out for, then there could be unintended consequences. Whereas you go the other direction and you pull in odor particulates for trespass that could apply to the right to farm, then we're not trying to find a bunch of different things that we need to carve out.
Okay, so you're saying only these things count as trespass
In the right to farm.
I
Yeah.
see.
Which is what Hawaii does.
So we can have alternative A and B. I think that.
Sure, I'll draft it as a committee amendment, but I'll do like basically bold, like option A.
Yeah.
Option B.
Yeah, on that one issue. And the one other thing is if you could add some, I know that we have it elsewhere in statute, but I want to make very clear that this bill, if it passes into law, will not affect any ongoing litigation.
Will do.
I have a B-side.
Yeah, no,
B-side, I'm gonna be the only one who's thinking of this, and if that's the case, then I'm fine letting you go, but in, page 5, the required mediation prior to suit, I believe you mentioned before, Michael Grady, that the Uniform Mediation Act does not address cost or profit there. And I didn't know if it would be worth, I've lost money, but if it would be worth addressing that.
yeah, I understand that there's also a mediation issue that didn't quite get resolved in Senate Judiciary at the end,
Yes.
and if you could, and Ian, I'm sure knows all about what that one is. Or will find out, so I'll find that in there as well. So, yeah.
This is a fun one.
Yeah, this is a good bill. This is a good bill. We'll get it there.
Okay.
Right. Thanks, Mike. And
Thank you.
so we're taking up,
Thursday.
yeah, we're taking this up again Thursday. If in fact we have some language that doesn't work out, we'll figure something out. So, but tomorrow we're going to do S87, and we have an amendment that is coming, language that both Ken McManus and Josh O'Hara suggested, and we'll have that language, and we'll take a look at that and hopefully be set